Al did a really great video over on Art of Law about Prince Harry discontinuing his claim against Associated Newspapers. It's this one here, so I'll link it in the description below. This first one here, Prince Harry did what? Filled out an N279 form. What's that? Well, Al will explain about the form and his thoughts about that in his video there. But discontinuing a claim has serious consequences, cost consequences. And lots of people have asked, although this is a high-profile claim, just about as high-profile as they get, lots of people have asked, well, what impact might that have on you bringing an ordinary claim and perhaps even a small claim? Bearing in mind there is no small claims court, there's just the county court, and any small claim, that being if it's a monetary value not more than £10,000, will be allocated to the county court small claims track. How do these rules affect those? Well, we'll cover that as well in this video. Because if you've brought a claim and you are the claimant and you've changed your mind, for all sorts of reasons, you might think that your claim is not going to succeed. You might just have a change of heart. You might run out of money. The other side might bring up a defense, which you think, well, actually, that's got some real chance of succeeding. Or, as in Prince Harry's case, you have an application for summary judgment and or strikeout, and the judge effectively says the defense is likely to succeed here. So then you go away, you speak with your lawyers, as we think was the case in Harry's case, and his lawyers have said, look, there's probably a good chance that this defense of honest opinion will succeed, and therefore it might be cost effective to withdraw at this stage. But withdraw, in this sense, means to discontinue the claim. That is under Part 38 of our Civil Procedure Rules. For those international viewers, our Civil Procedure Rules are the rules which are freely available. Here they're provided by Westlaw for educational purposes, and they're also on gov.uk. They are our civil rules by which all civil claims are governed, and likewise we've got criminal procedure rules. Those are the rules that the criminal courts will follow. So if you're discontinuing a claim, you'll follow the rules under Part 38, and the right to discontinue a claim is provided here. The bits in red are those that are recently changed, amended. And so at any time, a claimant may discontinue all or part of their claim. However, a claimant must obtain permission of the court if they wish to discontinue all or the part of claim, in relation to which the court has granted interim injunctions. Any party is given an undertaking to the court. An undertaking to the court is a promise to the court which you cannot break, else will be contempt of court, and various other things. There's a procedure for discontinuing. That's what Al talks about in his video. Again, I'll link that below. Essentially, you're filing a notice. And importantly, there are cost consequences. So the liability for costs here. Unless the court orders otherwise, a claimant who discontinues is liable for the costs which a defendant against whom the claimant discontinues incurred on or before the date which notice of a discontinuance was served on the defendant. So anything leading up to that date, because obviously they might have spent lots of money on legal bills to defend a claim which is then discontinued. Now, there is something that will feel very unfair to individuals that have had to defend a small claim, i.e. a claim in the county court that's been allocated to the small claims track, which is then discontinued by the claimant. Because the liability for costs under 38.6 sub 3 is that this rule does not apply to claims allocated to the small claims track. Now, this essentially means you as a defendant, because costs are not ordinarily reclaimable on the small claims track, this applies here as well. So a claimant can discontinue that claim and it still doesn't apply. Now, there is a narrow exception to these rules, which I will bring up, which I've used more than once in court to obtain costs, notwithstanding that the claim was on the small claims track. And that is this one here. That is under Part 27.14 sub G. And that is under the heading of costs on the small claims track. This is any case that's been allocated to the small claims track, which is a little technicality I'll come back to in a moment. Under sub G, whilst the court, as it says here, may not order a party to pay a sum to another party in respect of that other party's costs, fees, expenses, including those relating to an appeal, except And then there's a list of things that the court can order that party to pay. The simplest ones being the fixed costs attributable to issuing the claim in the first place. So obviously the cost of issuing the claim is a cost that the court can order the party to pay. But the bit that I'm looking at here is sub G. Such further costs as the court may assess by the summary procedure and order to be paid by a party who has behaved unreasonably. Now that typically will relate to the conduct of the litigation. So for example, if that party has not complied with any orders, if they've not complied with the deadlines, they've not provided enough information, or whilst the strict rules of disclosure don't apply to small claims, any furnishing of information and documents and things like that still do apply. So they do still have to provide those documents, and at the very least they have to provide evidence. But if they've not complied with the rules and the directions of the court to do so, then ordinarily under sub G, the court may assess costs to be paid by a party who has behaved unreasonably. So in other words, if you've got a defendant that is giving you the runaround and they don't comply with the court orders, they don't turn up and it's got to be adjourned and all of these sorts of things, the court may in those cases order costs. One example I've had is where I believe, and whilst there wasn't a court ruling on this issue, it seems like the judge was with me in that I believe one of the defendants was actually fictitious, didn't exist. So it was fraudulent in a sense, i.e. I believe, and I think the judge agreed with me, that this director just simply didn't exist. So he was a fraudulent, fictitious character. So in that case, the judge ordered costs. And likewise, if a defendant is accused and the judge accepts allegations of fraud, for example, this might be a situation where that party has behaved unreasonably. As I say, it's usually attributable to bad conduct of the litigation. And similarly, if a claim is moved from the small claims track to another track, either the fast track or the multi-track, then this rule ceases to apply. But as I say, lots of people have asked how this might apply to their own claims if they've got claims going on in court as well. And there's a technicality that I said I might come back to. Now, this I've seen mixed results in court, so take it for what it is. But a claim that is not yet allocated to the small claims track may still attract costs in the right circumstances. Although on the flip side, some judges have said, well, this was likely to be allocated to the small claims track and therefore the small claims track rules apply. In other words, the usual cost rules apply, which means you ordinarily cannot claim back your legal costs. So as I say, I've had mixed results with that one. In some cases, I have had costs awarded at, let's say, an application stage because the claim was not yet allocated to the small claims track. But I suspect a lot of judges will just apply the small claims rules because the claim is likely to be allocated to the small claims track. Another point to bear in mind, whilst I used the Harry case as a jumping off point here, this hopefully is useful to you. But another point to bear in mind is that by the time you get to court, the amount that you are actually arguing over may fall within the rules of the small claims track. So if the amount disputed is not more than £10,000, in my experience, the court will be allocating it to the small claims track and the small claims track rules apply, which means if you've shelled out thousands of pounds on lawyers, you're not likely to get those lawyers' fees back. And again, as I say, I speak from experience. I've argued this point robustly in court when the original claim and dispute was well over £25,000 or more. But they've agreed a sum just enough to bring it down to exactly £10,000. Strategic move, which on their part worked because the judge said, well, the amount challenged now is only £10,000. So this is now a small claim. So as frustrating as that was for the clients, the judge was not having it and said, no, the small claims track rules apply, which means you don't get your costs, even though we were successful in that particular case. And so obviously you might feel aggrieved having spent fees on lawyers that you can't claim back. Just something to bear in mind if your claim is well over £10,000, but the other party agrees just enough to bring you down to £10,000. But as for Prince Harry, obviously these legal bills are going to be hundreds of thousands of pounds and would have been hundreds of thousands of pounds more had he not discontinued the claim and ultimately gone on to trial and lost. But for more on my thoughts on that case, I'll link below, and over on Al's video as well, I'll link that below as well. I hope you found that useful and a useful jumping off point on discontinuing a claim and what you might be able to do. So if you found that useful, please do subscribe, and I'll see you next time.